Well, good afternoon. Thank you, Marinez, and good afternoon, everybody. Welcome to Association Leadership, episode 6. I can't believe we're there. I do appreciate that you do refer to us as experts, even though I don't believe that's necessarily the case, but thank you, Marinez. We do appreciate that. Good afternoon, guys. My name is Craig Vaughn. I'm the president of the Castle Group, and I'm happy to be here this afternoon, joined by Michael and Jeff, and we'll turn it over to them in a second, but welcome, everybody. As Marin has said, you're welcome to chat in your questions using the Q&A feature on Zoom, and we'll look to work those into the conversation. We've set aside some time late in the presentation to really answer specific questions. So I think we'll get there to this week, excuse me. I did want to remind everybody that we have changed to a leadership series right away from COVID. We're talking a lot about COVID right now, but we're also venturing into other topics. In 2 weeks, my partner James Donnelly is going to host episode 7, which is going to talk about these e-voting environment. We're going to talk about that a little bit today, but he's going to deep dive into e-voting. So that's on January 6th. We'll look forward to that. We're going to put you to work today. We have 7 poll questions as we roll through what worked last year, what were some of the changes in our environment. We'll start with our first question with a view to seeing who's in our audience today. So Ness, if you could poll question number 1, post it, that'd be great. And then guys, I wanted to, again, welcome you back, remind everybody that Jeff and Michael are here to give their opinion on the topics that we're going to discuss today, and not to give you specific advice for your association. So that for that advice, you should look directly with your association advisors. So guys, welcome back. Last one of the year. It's been quite a year. I'm sure you'll agree. But I would like you to take a second and introduce the firm. Michael, why don't you start a little?
Jeff's going to do that.
Jeff's going to do that. Wow. Okay. Jeff, go ahead.
Happy to. And I will say, and I won't miss the opportunity to let you know that Michael and I are, in fact, experts. We're board certified experts. 9 attorneys at K. Bender Rembaum. 9 of 19 of us are board certified experts in this field. We represent only associations, sometimes a developer on occasion that might be building associations, and an owner claim if it's the right type of claim, but primarily over 1,400 associations we represent. We have offices in Pompano Beach, in Palm Beach County and Palm Beach Gardens. We have an office in Tampa and by appointment in Miami-Dade County. We publish 2 publications. My partner, Robert Kay, publishes Legal Morsels, and I publish Rembaum's Association Roundup. Both of them are keeping you in tune with new court cases, legislation, and how they affect our day-to-day living within our community associations. Also, Robert Kay hosts a radio show, and Peter Mullengarden hosts another radio show, both specifically dealing with association-related issues and questions. Michael is involved up to his eyeballs in all sorts of association legislation in Tallahassee. And Mike, you have a different location today. What's going on with that?
Good afternoon, everyone. Thanks, Jeff. And yes, thank you for pointing that out, Jeff. That was going to be my first comment too, that some of us are experts. We've worked hard to become one. Experts.
Yeah. By the way, just as an aside, I've talked to both your wives, neither of whom think you're experts, but that's another issue for another day.
Being married, I'm learning something new every day.
Anyway, but yes, you do. I have a location. I am just to the point of our first topic, which is COVID and to the year 2020. I am actually at home this week, and when a family member of mine did test positive last week, thankfully they seem to be relatively symptom-free. But as a result, myself, my family, we've been self-quarantining this whole week, and actually went for a test last night. So we'll get our results tomorrow. So far, so good as far as we're all feeling good. But it's real, and it's still out there, and everybody please be safe.
Excellent. Okay, guys, let's quickly talk through the agenda. We're going to hit on a bunch of issues we've talked about in the past, kind of revisit them, and then a couple of new ones as well. So I've got on my list the emergency order, amenities, and the opening status. What are your neighbors doing? So we check in on that every session. Snowbirds, welcome back. Zoom meetings, e-voting, 2021 legislative forecast, rentals, and what to do now, rule enforcement, and then some questions and answers if we get to them. But before we jump into the emergency order, Marinez, will you share the results of the first poll? Where do you live? I think we have the same people listening to us every week, which is great. About half and half HOAs and condos, and of the HOAs, about half of the HOAs, actually 25% of the HOAs in what we call 55 and better communities. And you will be reminded that we refer to them as better since James and I each turned 55. So that's been 5 years now. Let's jump into thank you, Marinez. Let's jump into the emergency order, guys. January 3rd, 2021, set to expire. You will recall in November, the governor extended it to 60 days to January. So we're on the cusp of that again. And I thought it'd be fun to ask our audiences what they think the governor is going to do with respect to the order. So Marinez, can you post poll question number 2 before I ask Jeff and Michael their thoughts? Do you think the governor will extend the emergency order? So let's see what everybody says. And then I'll ask our experts what they think. Jeff, why don't we start with you? What are your thoughts?
That I love this new polling feature. That's what I think. I love this new polling feature. We get to see it in real time.
Yeah.
So cool. Does everyone else get to see this the same way we do?
Not until we post it.
Not till you post it. Well, this is really, because she screen shared with me. That's why I'm seeing it. Okay. Really nifty. I love that. I think he's going to extend it at least 30 more days, if not 60. Mike, what do you think?
Yep. I'm cautiously optimistic that our governor will be have the foresight to extend it for at least another 60 days.
Okay, let's end the polling, Marinez, and see what our listeners have to say about that. Okay, so looks like the majority of us expected to extend 30 days, 40%, 60 days, 38%, and not extend 22%. So, it'll be interesting to see what he says. And
yeah, I wouldn't be surprised if any one of those 3 are the results. Quite frankly, it's
That's a safe bet.
Yeah, that's a safe bet. Well done. Yeah. I think that we will reserve bragging rights when we revisit what he actually does next webinar. But just so I make sure we have it correct, even if he does not extend the emergency order, we still have some time. We still have some time to respond, right? As an association, do I have that right?
You do. In fact, the legislation for condominium, cooperative, and homeowners, when it comes to the emergency powers, conclude the legislation with the following sentence. Special powers authorized above shall be limited to that time reasonably necessary to protect the health, safety, welfare of the association, its owners, family members, tenants, guests, agents, invitees, and shall be reasonably necessary to mitigate further damage and make emergency repairs. You have to remember this legislation was not designed with coronavirus in mind. It was designed with a hurricane in mind. So you've got to really have a rational basis. If you're going to rely on those emergency powers, you better be able to justify it as to why you are exercising them. You can't just use them because you want to.
Right. And so, Mike, let me ask you a question. Play this out. He doesn't extend the order. Jeff said we have time, but in the near term, what changes our association is going to have to make, do you think?
I mean, Craig, that's a great question. Also, I think a difficult question to answer, certainly in the time frame we have. But I think it really depends on what it is that you as an association are doing right now.
Right.
And why and what is your basis or reasoning for doing what you're doing right now? If you are an association that has limited access to amenities, then I think you have to potentially revisit that to see what's the basis for that and can you continue with that. The facial covering mandates, as far as I'm concerned, my opinion, so long, and I'm speaking now personally as well, as long as this virus continues, and it is continuing, I mean, the numbers in Florida are not going down. Facial covering mandates, I believe, are something, and I think we'll briefly talk about them later. Facial covering mandates are absolutely something the board can reasonably argue it can be kept and enforced.
Right. Okay. Good. Well,
I think it's important. You're going to need to look at what you have now, and then get with your attorney and discuss with your attorney and your management team, what it is you're doing, what you can continue to do from a legal and business standpoint.
Right. Good stuff. Okay. So good news is even if they don't extend on January 3rd, we have some time. So we'll have another webinar to talk about that process, depending on what happens. Because I want to move on to amenities. One of the things our listeners have said is they appreciate that we kind of tell them what's going on with their neighbors. So I do want to do that, go through that process again. But before we get to that, Michael, you just said the number of cases are increasing significantly. So with that as a backdrop, Nez, can you post poll question number 3? With the increase in cases in the last month, have you made any changes to your amenity use restrictions? So let's see what our listeners say about that. As we wait for them to answer that, Michael, you know, we are seeing some questions. Can an association require returning residents to quarantine for a period of time? Number one, so as our snowbirds come back, or get tested? What kind of advice are you giving your associations?
Oh, when this back in March of this, I guess, gosh, I was going to say March of but no, it's March of this year. It just feels like years ago.
Exactly.
There was an order that was implemented requiring out-of-state visitors, especially from quote-unquote hotspots, to have to quarantine for 14 days. That order was lifted in the summer when the numbers actually were decreasing. And there is no such order mandate. I don't believe an association has the authority to mandate that any owner or resident coming in from out of the area have to self-quarantine. I don't think they can mandate. Can they request? Can they recommend? Can they urge? Can they ask that these individuals test when they get here and confirm that they're negative before using common amenities? All of those things, yes. But I don't think they have the authority to mandate.
Both quarantine period and a positive test, or a negative test again.
I'm saying that listen, again, if people are coming from out of state, they're traveling in, flight or otherwise. I mean, it'd be great because it doesn't cost anything to go get the PCR test, not the rapid one, the one that's more reliable. Results in a lot of places come back in a couple of days. And listen, then you show up, you get your test, you show you're negative. And I'm just saying this to those who are coming from out of state. That would be something that a community can ask, can request. But I don't think you can mandate.
Yeah. Jeff, your thoughts?
You can't lock someone in and say, we'll let you out in 14 days.
Jeff,
Right.
what should our associations do?
Sorry?
What should our associations be doing?
Taking reasonable measures. Like Michael said, you're not going to be able to lock somebody in their home for 14 days. You can certainly have some guidelines if you wanted to. If you're, and you could, when people check in, it could be a reminder on an 8.5 by 11 piece of paper. If you've just come from an area where there's a high rate of COVID-19, please be respectful of your neighbors. Please be sure to socially distant. Wear your mask in the elevator. Post signs everywhere reminding people to wear their masks and socially distance. Things like that.
Okay. Let's show the results of our, thanks guys. Let's show the results of our question. And it looks pretty much like status quo. 10% have actually increased their use restrictions. 9% have decreased them. Interestingly, most are status quo. 79, 80% are status quo, which I think makes sense. That's kind of what we've been recommending to our clients.
All right, guys, gonna say, if you are a community where you're seeing a lot of snowbirds are now coming back, I think one of the other things that you should be considering association and with your management team is you likely need to do more sanitizing of those common areas, of those elevators, of those air hallways and places where the residents are now visiting more frequently.
Yeah,
you might consider that.
Yeah. Okay, good stuff, guys. Let's. I want to talk about masks, Michael. You touched on it quickly. Can you just remind everybody of kind of where we are with respect to mask rules and what we can do from an enforcement standpoint?
I don't think that in our opinion, this has changed. I mean, I know that there's been some question because the governor said that municipalities can't fine. That doesn't impact an association. If you properly adopted a facial covering rule, and it's important that you're properly adopting, that means you're holding a properly noticed meeting of the board where you're adopting this rule. And the rule is impacting the common element areas, common amenity areas. So it's a 48-hour posted notice. And then you properly vote, you motion, you second, you adopt, and then you publish it to the membership. That's an enforceable rule, and you can and should be enforcing it. If people are not following it and you have a fining committee in place, you can be fining for that. You can suspend people's use and voting rights if you have that committee in place. And should it become necessary, you can take further legal action like you would with any other rule that's being violated.
Good stuff. Okay. Okay, Marinez, will you post poll question number 4? So over the last 4 months, guys, we have asked this question, to what extent are your amenities opened? We had I've grouped it all together this time because as we did this, the kind of results between condos, co-ops, and HOAs all converged around almost the same numbers, which was interesting. So the last time we did this poll, we had about 95% of pools open, 60% of gyms, and 25% of clubhouses. So just to give our listeners some perspective on where they stand relative to, our world, if you will, in terms of number of residents, number of communities on here now. Let's see where they end up. Marinez, can you just post those results if you don't mind? So is your pool open about the same? A few less guys, 88%. No pool open, 9%. And Jeff, I'm going to get you to answer the question after. You don't have to open your amenities, but let's come back to that in a second. Have you opened your gym? 50%, basically the same number. And this is consistent with have you changed your enforcement or change your rules? And then have you open your clubhouse? I can't see that, guys. Can you move the clubhouse down so I can just see the results there?
I was able to scroll it up.
Yeah, 23%. So basically no change, which is consistent with have you adopted new restrictions. So Jeff, one, any surprises? Two, you don't have to open your amenities. And there was a specific question from a listener said, do I have to open it, especially if I don't have the resources to clean it? So can you comment on that?
Sure. You don't have to open it. That's the bottom line, but I think you need a reason as to why you're not opening it. For example, because you do want to provide that extra cleaning. You're not able to because you don't have the financial resources to do it. I also begin to think that now that COVID is becoming, more routine, that individuals, to some extent, have the right to make their own decisions. If they want to go to the pool area and socially distance, well, that's something I think they can consider. Mm-hmm. And I think boards have to be responsive to the entire community, not just how you may feel yourself as a board member, but how does my community feel? Sort of a democracy, right? We're representing the interests of the community. How does our community feel about this? And if you're getting a lot of flack because your amenities are not open yet from certain members, then consider polling your entire community, similar to the polling we do here. And any way is possible, right? You can use monkey survey, you can pick up the phone. There's lots of different ways to survey people to find out the general consensus, if you will, of the community, and then perhaps go in that direction. But at least that way, if your amenities are not open and you have a member who's just constantly knocking on the door saying, open, 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 this isn't fair, it is a board decision, obviously, but it's just not made in a vacuum. And you're able to go to that person and say, listen, 80% of the people here don't want this open right now. So we're going to respect that, depending on how it goes.
And what about the use at your own risk?
I had 2 points quick to add. One, I want to remind everyone, Broward County order is still in place, which specifically states that you need not open these amenities if you don't believe you have the ability to enforce the restrictions that are in the order. And the second point, and to what Jeff is saying, I agree, I understand, but I also want to remind when you're considering this, unfortunately, we still have the situation of liability. There are efforts being made, at the federal level, which they look like they're going to back burner, and at the state level, which will be coming up in session to try to, address liability, immunity from liability. I continue to push to get associations included as one of those business entities, but you still have that question, and so that becomes a factor. Unfortunately, because people do bring claims that aren't necessarily based in fact, but they still have to be defended. So ultimately, that becomes a factor when boards feel they can't properly monitor or sanitize, etc.
Okay. One question we have chatted in here is if the owners are asking for a reduction in dues because the pool's closed. I know we've addressed this a number of times. It is a recurring question. And, the fact that your pool is closed may be a reduction in your pool service costs, but there's other costs that may be increasing at the same time. So the impact on your budget is really independent of shutting the pool. It's everything else that's going on in the community as well. So I think to answer that question, no obligation to.
You're still required to maintain the pool.
Yeah.
So the expenses are still there. Yeah.
So the answer to that one is you're not required to reduce your fees if the pool is closed.
Correct.
Okay.
You are required required to pay your dues even if you can't use the amenities.
Yes, yes. And there are some questions around, by the way, another person asked how many associations are represented. We have about 260 people, participants on the call. I don't know how many independent associations that is, but it's a reasonable sample size. So I think it's it's probably statistically relevant from back in my one statistic course I ever took in college. But okay, well, that's where we are kind of on amenities. Let's move on to Zoom, virtual meetings. And Zoom has done a phenomenal job of, I think, capturing that whole market, because we actually now refer to them as Zoom meetings in our office. As we look back, I think this is one of the things that worked. One of the trends that's emerged is the whole virtual meeting concept. But before we jump into a discussion, Ness, I want to continue to get our listeners to work here. Can you post poll question number 5? Has your association been holding its board meetings virtually, in person, hybrid, or I don't know? And what I would ask, guys, we've become Zoom experts. I know you guys are as well. Michael, do you think
Yes.
what do you think about this? And do you think it's here to stay?
Yeah, I think Zoom has become the Kleenex of virtual, right? Yeah. Oh, I absolutely. I think it's definitely here to stay. I think it's, well, I do miss the in-person. And I think that there's there's some aspect of that will be nice to come back. And in particular, when going out and doing classes and education programs and stuff, these virtual, I absolutely want to continue to do this, because this is this becomes an added feature, both for the education, as well as being able to meet with clients or even prospects who would otherwise be challenging to meet with. You have a board who, as Jeff mentioned, we have clients throughout the state. So we have boards who now want to meet. And if they call me at 5 o'clock and say, listen, are you available at 6? Yes, I can do that. Boom, send me a link and we can jump on a quick meeting. Yeah. And then there's no travel time either.
Yeah. And it used to be.
Yeah, the virtual stuff is absolutely here to stay. Go ahead.
And if a client in Lakeland wanted our services, it may not have always have been practicable in the past. Now with Zoom, it is. We can service any association pretty much anywhere in the state.
Yeah.
No problem.
Jeff, for you, and we're going to get into the issue, some of the controversy on the whole authority to be able to hold Zoom meetings in a second. But before we get there, any pitfalls board should consider if holding meetings by Zoom?
This is a good time for me to do the screen share.
Okay.
All right. So I'm going to go ahead and do that, everybody. Just bear with us while I push a couple buttons on this side.
And while Jeff is doing that, I just want to also point out, it's not just about us. I think for members as well. You have members who are around the state, around the country, around the world. These virtual meetings allow them to join in when they otherwise might not be able to, which is why I think this virtual stuff is here and here.
We feel the same. Greater participation.
We're working on doing some legislative amendments too that will clarify that.
All right. Is it working?
It is.
Outstanding. So Lucky Strike Extra, 5 slides. I'm in the middle of putting together a new presentation, new course for those that want to join us, Community Associations in the Digital Age. And it will cover a whole lot of different subjects dealing with electronic and virtual meetings. So in 3 minutes or less, Lucky Strike Extra, remote meeting best practices. Remote is another word for virtual. All right, fine. When do you use them? When there's no appropriate physical location due to social distancing guidelines, when it's a serious matter of common interest to the owners, including your demographics, as an option in addition to physical attendance. How to prepare. Disclose the intent to the members. You have to manage their expectations. Disclose the reason to the members. Don't let there be surprises. Describe to them in writing how they'll be able to join and participate. Encourage the members to ask questions in advance if possible. And if you're at an election meeting or you're taking place with voting and you're not set up for e-voting, have ballots and proxy forms available at the physical location of the meeting if possible. Then, best practices. Establish the ground rules at the beginning of the meeting or in advance. Be explicit. You need a roll call system, either in chat, by voice, or poll questioning. We'll talk about 617 in a minute. Allow time for member and proxy registration in the chat feature. Control the member comments with administrative user features. Require all members to state their name, number, address before speaking. And if you're doing voting, always open ballots in view of the camera for owners to watch. Now we're going to take 2 seconds, talk about board meetings, virtual board meetings, then virtual membership meetings. So when it comes to board meetings, we go to the Not-for-Profit Act, Section 617 0820 Florida statutes, unless the articles of incorporation or bylaws provide otherwise. So you have to check your governing documents, the articles and the bylaws, unless they say otherwise. The board of directors may permit any and all directors to participate in regular or special meetings by or conduct the meetings through the use of any means of communication by which they can participate and simultaneously hear each other during the meeting. The director participating is deemed present. But remember, you also have other requirements set out in your specific legislation, such as the required notice for posting of agendas, etc. Also, you have to perfect the member's right to comment at the appropriate times during the meeting. Then our final slide is remote member meeting best practices. And here we refer to section 617.0721 Florida statutes. Now look at the language in red, and that's what Craig was referring to a few moments ago. There is some chatter that I think even started, Craig, on our sister show regarding the need for prior board action before a virtual member meeting takes place. Well, here's where that chatter comes from. We look at the statute and it says this: if authorized by the board of directors and subject to the guidelines and procedures as the board may adopt, members, proxy holders not physically present at a meeting may, by means of remote communication, participate, be deemed to participate if, and then there's some other requirements there. The corporation has to implement reasonable means to verify each person being present, and various reasonable measures to provide a reasonable opportunity to participate in the meeting. But let's go back to the beginning. How can the board make those decisions if not at a properly noticed board meeting? Remember, if authorized by the board, that means, let's break it down, the board has to authorize it. How can they make a decision if you're not at a meeting? That's where this is coming from. If authorized by the board of directors and subject to such guidelines and procedures as the board of directors may adopt. Work with your association's attorney. They can help you prepare the guidelines and the procedures as well. I hope to see many of you at the course, Community Association in the Digital Age, once we offer it in a few weeks. And with that, I'm going to turn it back over to you, Craig.
Okay, so guys, I think what has come up here is the concept of, I guess, simply and in a non-expert language, if you will. The issue, as I understand it, is associations needed some authority to be able to conduct meetings by Zoom. Is that right?
They need authority. I think the emergency powers themselves lend themselves in that direction. Okay. But I think now is where, this is new to everybody as we've been going through this process. So as we acquire more information, as we dig deeper, as other things come to our attention, we'd like to share that with everybody in our viewing audience. So that's where this is coming from. If you want to dot your I's, cross your T's, you'd never want to leave your flanks exposed, right? For an owner to argue, hey, you didn't do this right. So here we go. We can close this loop down real easy. It's super easy to do. Next board meeting, doesn't matter when it is, make a motion, right? Board meeting. I move that we hold our membership meetings virtual. Boom, done.
Right. And I mean, listen, not to toot the firm's horn, but Jeff, I thought that was very, very well. And the 5 minutes or less is what I'm most impressed with.
Well, that's the most impressive, actually.
No, really. And I hope for those of you listening, that was a really succinct. And as Jeff mentioned, we'll expand upon that in the 1 hour course. But Craig, to your question, I think the way the last two slides Jeff put together really nail it. The ability for board members to meet in board meetings, telephonically or, by speakerphone or extending it to this virtual setting has been in place, and it's mirrored and it's piggybacked by your 7/18/1920. So boards should be holding those meetings, and at those meetings, even if the board is meeting, if it's a board meeting virtual, because the articles and bylaws don't somehow preclude it, which I've personally not seen one that does, then at that board meeting, as Jeff pointed out, that's when you are going to address future membership meetings. And to the extent you might have held meetings virtually, member meetings previously, and you might not have done this in accordance with 617, and then that's a simple ratification. Get with your attorney. You can do it, add to your agenda, your next board meeting agenda, where you're approving a future as well as ratifying prior board action, prior actions, and the membership meetings, and you'll tie all that up and eliminate those issues.
Fantastic. Okay, that's great guidance, guys. A question we get a lot, I know at Castle, is can I mute everybody and have them chat in their questions at a board meeting?
No.
Or do I have to give them the opportunity?
No. Stop.
We take the firm opinion that if people are invited to, members are allowed to attend and speak. And while, to Jeff's point on his slide, where I thought it was great, he said, and encourage people to submit questions in advance if possible, which is helpful. But if an owner is on the call, the Zoom meeting, and they want to speak, there should be a mechanism to give them the floor. Now, if they are taking advantage of that, then there hopefully is a mechanism where you can turn them off. That's something I know that the Zoom platform might need to work on, depending on whether you're using Zoom meeting versus Zoom webinar. But absolutely, if they want to speak, they should be able to speak, not just chat.
We've seen a bunch of hybrids where you're welcome to chat in your question. We'll answer any that come up as a board, and then does anybody want to speak? We can, let them chime in now. So that's kind of where we've been heading.
Craig, I want to read directly from the statute so the listeners hear this, all right? 72303, but if you go to 718, it'll have very similar language. Members have the right to attend all meetings of the board. The right to attend such meeting includes the right to speak. The legislation says speak. It doesn't say communicate. It doesn't say communicate in writing. It says speak. So therefore, we have to perfect the members' opportunity, right? To let them comment on anything that is on the agenda or discussed by the board. For those of you that are waiting till the end of the meeting, I still suggest to you, you're doing that incorrectly, because by then you've made your decisions. You should either allow members to speak at the beginning of the meeting, like a government does, or more appropriately during the discussion of the board at the appropriate time.
Right. I think you did hit on a point. There are, depending on whether you're using the webinar feature in Zoom, which is the one we know, or just the normal Zoom meetings. Even in the webinar portion, you can reach out to the people and you can unmute their mics and let them speak. So it's another feature, not used as much, but we do have one question about the large community size. We have to sign up for, do you do it by webinar with the board and panelists like we are? We could unmute and allow people to ask questions. So that is a feature.
One of my clients, Craig, I just went to a board meeting the other night. They had about 100 people there, and it was really simple. Once the board finished their conversation, we had a motion pending and a first, a second. The board exhausted its conversation, then went to the membership, and the moderator who was running the Zoom meeting said, just, click your hand, put your hand up. And showed everybody where the button was, and then we just orderly gave everyone their 3 minutes. And if they were abusive, it was so wonderful, you just unclicked them and muted them.
It is the conduct we love the way the meetings are conducted, because there's not as much emotion around an issue, because you speak your 2 or 3 minutes. And is 3 minutes the law, or can you set a reasonable time frame?
You set a reasonable time frame.
Well, in some instances, the legislation does say 3 minutes, and I'm not going to tell you which ones. I don't want to get it wrong right now. I think it's board or membership. One of the places that says reasonable, another one it says 3 minutes. We have a opinion from Tallahassee where there was actually a 2-minute right to speak, where it used the word reasonable, and that was okay. But I think Michael and I pretty much stick with the 3 minutes with all of our clients.
It seems to be certainly seems to be the rule of thumb in our world.
Craig, it's something to the point of when you're adopting rules, procedures, you should be adopting reasonable rules and regulations or procedures governing meetings. And that's something that the board should adopt, that says owners will be allowed to speak. As Jeff mentioned, I agree. If it should be, if possible, during each agenda item. If that's not working for some reason, then before, not after. But that said, boards can decide to do it after if that's what they choose. It's just not, good business practice, in my opinion. But that's where they should say you'll be allowed to speak for up to 2 minutes or up to 3 minutes. Adopt that, make it clear, like Jeff said, make it explicit up front. Here's our meeting policy. And when you're doing these in person, by the way, have a sheet. Here's our procedures. As people walk in, hand them the procedures via Zoom. You can have a little sheet up there like Marinez does up front, or whoever does up front, where they have that put that when the people first check in, here's our procedures that we're going to be following.
Right.
I think it's the member meetings that have the 3 minutes, and perhaps the board that says reasonable. Or it might be opposite that.
Well, I guess the reality is, I think the rule of thumb we hear all the time is 3.
3, that's where it comes from.
And it's a long time to speak actually on something when you really sit down to it. But I would suspect that if you had specific question on that, you could get with your attorney. Nest, remind me where I am. I've lost a little track of the poll questions because there were so many. Have we asked our audience to answer the question, your experience with virtual meetings? If we have not, can you post that? while we wind up the e-meeting discussion here.
Wait, we asked but didn't get the results.
No, I don't think we did ask this. We asked how many people are holding their meetings virtually. Now this
And
is
we-
about.
Why,
Yeah, but
why
did-
does this poll question say, does Craig need a haircut?
Craig, did we get the results for that last question though? Are they doing it Zoom or in person or
We're still
hybrid?
voting at the moment.
No, we will go back and we didn't, Michael. So when this is done, I'll have Marinette post that. It's a good point. Last thing on meetings while people are answering this question, then we'll show the results of both. What recording? You know, you have the record feature. We do have people recording. You can videotape and record a meeting without anybody knowing. Any rules, regulations, anything we should be concerned about in that regard?
Members have the right. They have the right to record the meetings now.
Yeah.
Yeah, there is you know, in the administrative code, you can adopt a rule that requires people to give advance notice if they're going to record. For in-person meetings, that works. For these virtual meetings, it becomes obviously a much bigger challenge.
Okay. A question just came in again while we're looking at this. What if a resident is obnoxious when they're in their 2 minutes or 3 minutes? Can we mute them?
If you adopt rules before
Great
the
point.
person is being obnoxious. So when we adopt rules for people, and I will paraphrase, everyone has their right to 3 minutes. Just because you ask a question doesn't obligate the board to answer. The board might answer. You need to act as an officer, as a gentleman, as a lady. No cussing, no swearing, no yelling, no inciting a riot. Remember, you're addressing the board, not the membership. If we're at a board meeting, if you violate these rules, then you may lose your right to speak. You voluntarily abrogated the right to speak by violating the rules.
Well, I think that's great, guys. All falling back on what both of you have said, you'd adopt reasonable rules with respect to the conduct of your meeting. You make them available and you communicate them to everybody, and that gives you some leverage as a board on what you can and can't do. I think that's
right. And you should run them by your council to make sure the rules you're adopting are enforceable and not running afoul.
Yeah.
But when you say someone being obnoxious, obviously that's very subjective. So you got to be careful what that means. Someone can be obnoxiously asking questions or making their opinion known as, that doesn't lose their time. But you know, you got to deal with that on a case by case.
Right.
We all know what we're talking about, though.
It's like the Supreme Court's definition of obscenity, right? We know it when we see it.
Yeah. Marinette, so let's go back. I think we're going to go back to question number 5, which is how are your associations holding meetings?
Yeah.
And wow, 70% virtually,
70%
10% in person, 18% hybrid, which is I think where this is going to all land. You know, when the dust settles, is probably more and more hybrid meetings. So the people in the community can come in if they want, and you know, they still hold it virtually as well. But guys, any surprises there?
Nope.
I know it's a surprise. I mean, I did say wow because I guess it was 70% are doing all virtual, which I guess makes sense because primarily all the meetings I've been attending with boards have been, you know, they've asked us to attend, myself or others in our firm have been virtual. So a few have been in person, but very few.
And it's been wonderful. It's just been absolutely wonderful.
It is. And then let's post the results of number 6, which is how do you, how do you feel about the meeting? Describe your experience with virtual meetings.
Okay.
So it looks at largely 76% positive, 8% negative, same 6, and we have not had a virtual meeting, a subset as well. So I think this is where this is kind of where it's headed. Usually it's a positive experience. We actually find it much better, especially with some of those boards, you know, that have some contention in the community. It seems to be much more civil. There's not a piling on sense, you know, when you get an issue raised. So anyway, good stuff. Great discussion, guys. Let's move on to e-voting. Another thing that's come out of this pandemic for us and these changes in our landscape. So let me make sure I get the question straight here. Last question, Inez, number 7. Is your association considering e-voting in 2021? While that question comes up, you know, it's annual meeting and election time in our world. Michael, let me ask you, if association wants to use e-voting, what do they have to do to lay the groundwork, if anything?
Well, in very, very simple terms, what they need to do, the board does need to adopt a resolution with a 14-day notice. And quite frankly, Speaking candidly, we've asked Tallahassee to remove that requirement. It seems unnecessary that the board has to give a 14-day mail everybody a 14-day notice that they're going to meet to consider a resolution to electronically vote. Because then if they do pass that, then they have to notice the membership, hey, we're doing electronic voting. Do you want to opt in? But regardless, right now the law says the board has to do a 14-day notice and mail it and post it to everybody that they're going to have a meeting. And at that meeting, they have to adopt a resolution which clarifies what their process, what they're going to do, what the process is, cutoff dates, and that. And it's something, again, you should be getting with your council to make sure that you have the documentation in order and the process done correctly. And then you're reaching out to get a third-party vendor. There are several third-party vendors who are very experienced in electronic voting. You want to vet them. They'll do virtual tutorials with the board and management, so that you can get a level of comfort for what it is they do, how they do it, price shop, just like any other vendor. Have your attorney review the proposal like you would any other vendor. And that's the general gist of it. You start with vetting some third-party vendors. You can get referrals from, we can give you some referrals, others, vendors, and schedule a board meeting to approve a resolution that you're going to consider, that you're going to be doing electronic voting in 2021. And not just for annual meetings. I know I'm jumping ahead to a question, but not just for annual meetings. Electronic voting is especially, I think, really beneficial when you're trying to get amendments passed. And if you're working on votes on, waiving the reserve question, waiving or partially funding reserves, or if you have alterations that you need membership approval to support. So this electronic voting is a process, I think, that every community should be considering. It's an option. It's an either or. You're not going away from paper if people want to still do paper.
Mm-hmm. Mm-hmm. And you don't have to adopt a resolution for each vote. Once you've adopted the resolution to move to e-voting, you can do it for any vote if people opt in, correct?
Correct. And once you opt in, you're opt in unless you choose to opt out. You don't have to opt in every single time either.
Right. Well, we've to your point, we've seen some real success in getting amendments passed, which sometimes in the past were very difficult, right? You mailed it out to everybody. You waited for the ballots to come in, you counted the ballots and you didn't have enough. Then you mailed it out to everybody again. And, the software allows you to ping people on a regular basis if they haven't replied or sent their ballot in. So it's been a great feature. And again, for the waiving of reserves for those associations that need to do that same process. We just did one for an association, or we participated in one. They were seeking a material change to the community, and they were very successful where they had been unsuccessful in the past. So a great platform. Jeff, let me ask you, it's annual meeting time. By the way, the platform is very simple. When you're doing simple things, it gets more complicated as you do more complicated things. Annual meetings sometimes can be complicated. What are you thinking about annual meetings and elections with respect to e-voting? Are your clients using it?
Limitedly, not as many as I would have thought, but I think as time goes on, more and more are beginning to. It's especially useful in your larger communities when you have over 400, 500, 600 homes, some communities 1,200, 1,400. It really does help simplify things.
Right.
It sure
And it's a quorum.
Yeah. Get quorum, yeah.
The HOA, obviously the condo world, you don't need the quorum, but in the HOA world, it does help you establish quorum too.
Mm-hmm. Right. And it also, in its own way, there's sometimes a danger when you're at a live meeting, any member can make a motion. I move blank. And if it gets a second and gets traction, who knows what could happen at that meeting. Whereas if you're using the electronic voting, it needs to be already thought of in advance and presented to the membership. So it gives you a little more control.
What about for those?
I would clarify, when I said you don't need quorum at a condo, I was speaking for an election. Obviously, you need quorum to conduct the meeting.
Right. What about those HOAs that you can accept nominations from the floor? Any restrictions on?
Oh, that's such a good question on that one. When you're, especially now when we're moving into the Zoom platform and the association allows nominating from the floor, how do you deal with that? And I had to wrestle with that just yesterday for an association. And one thing we do is on the proxy form itself, you leave a couple of blanks so people can write candidate names in. In the instructions to the members, we affirmed the members' right to, nominations can be accepted at the floor of the meeting. However, remember everybody, it's going to be a virtual meeting. And by the time you do those nominations, everybody will likely have already voted anyway. So please bear that in mind. But if you're insistent and you want to do it, you will have that opportunity. That kind of, discourage it a little bit.
Yeah. Let me put you on the
Two
Go ahead,
things.
Mike.
One I'll say is I would encourage HOAs to consider amending their documents to run more like a condominium election, so you don't and not have nominations from the floor. It just runs more smoothly. Secondly, if you do require nominations from the floor, and it's something that we've done and we've done successfully, and I think I mentioned this at a prior webinar, it is an extra expense, but you can consider doing a 2-part annual meeting, where if you have to have nominations from the floor, you call the meeting to order. If quorum's been established, you take nominations from the floor. They say there's 5 seats. If you get 5 or less, then you have your seat. You do other business. You adjourn. But if you get more than 5, well, then you recess that part of the meeting, and you then do a mail out, where you then mail out like a condo. Where you mail out the ballots, because now you have your nominations in place. You mail ballots out. You send them out. You recess and reconvene for part 2, like in a month. And then you send them out and everybody votes. And when you reconvene part 2, quorum's already been established. In front of your cameras, as Jeff mentioned his thing, you're opening those things and you're counting just like you would in a condo. And that's where now you've met. I think that's a creative way of complying with the statute and allowing people to participate.
That's interesting, Mike. We'll have to add that into the new course.
That's a great recommendation, Michael. That's very cool.
That was really good. Yeah, that was good.
Let me put you guys on the spot for a second.
I copyrighted and patented that. Anybody trying to use the KBR thing.
Let me put you on the spot for a second. So I voted electronically and they nominated someone from the floor I really like. Can I change my vote?
No.
You cast your ballot, right?
When you cast a ballot in a condo, it is sacrosanct. You cannot get it back. When you're voting by proxy, there is an opportunity to make changes when you're voting by proxy.
I thought they had submitted their vote already.
Yeah.
No, they said they submitted it, but they said they voted electronically. They've already submitted.
Oh, if you vote electronically, you're done. It's toast. There's no way to do that in the system.
Well, guys, I would say the e-voting, the ability to use e-voting has been around for some time now. I think, if I remember correctly, it's just we're really starting to get into the practical process. And what I would say to the boards considering this, and Marinez, maybe you could post results of question number 7. Is your association considering e-voting? So half, yes.
Well, that's jumped up a lot, because I think prior to this year, it would have been more like 15%.
Yeah, that's probably one of the only positive things that's come out of COVID-19 is Zoom and electronic voting. But Craig, what about, Castle is so electronically advanced. You guys are digitally advanced. I'm not sure the words to use it, but you guys are just light years ahead of the curve. Right. When are you guys going to come out with a e-voting platform for your client base? Is that something that might happen?
I don't think so. There's, we let the software development get done by the software development experts.
Okay.
And I think, we don't want to get boxed in. There are several good vendors. They all have, different taste, and we let the boards make those decisions.
I think, Craig, I think that's spot on. I think to your point, there've been electronic voting, at least in other states, for more than a decade. And some of these companies have brought that technology into Florida, because this was put in this has been around like 2-3 years at least, maybe 4 now. Yeah. 2016. So yeah, and they've obviously they've been understanding and perfecting the use of that platform with Florida statutes. Yeah. And so I'm of the same mindset. You get a third-party vendor, this is their role, just like you guys are management. We're association council. You get a third-party vendor who comes in, and by the way, who'll stand behind their product. Yeah. Who will say, listen, this is what we do, and we will, if we screw up, we're going to be the ones responsible. And I think that's important. I think you got to separate those.
I would say that this is not something you want to go through the first time without your attorney around to answer questions that a residents inevitably have, and to have, your management company around clearly, because it is a muscle that isn't well used yet, and there's lots of questions. And so, but we've seen some real adoption. The association I was telling you about, on the material change, 76% of the residents opted to vote electronically, which is unbelievable when you really think about it.
Yeah. Who
potentially would never have voted before, right? They just wouldn't have taken the time to open the envelope and pull the ballot, pull the stuff, and
right. Even if it's a no vote, at least you're getting participation, because that's where it starts. Because then at least now you have a method of communication with them where maybe they'll get more engaged.
Right. Okay, that's a great debate. And again, my partner James will be addressing this issue in a couple of January 6th. So tune in and get some more information. Jeff, we'll look for your course. We have had a number of questions saying like, okay, when can I take the course? and we should probably let you finish it before you give it. But the invitation, I'm sure, will go out to everybody who's on our database. So
Yes, it will.
that would be, we'll anxiously look forward to that for sure.
Look for it in January 2021. I'm putting Jeff on the clock.
And make sure you give appropriate kudos to Michael on his creative idea about opening and adjourning a meeting.
He doesn't know it yet, but he's going to draft a slide with that information that I will then incorporate into the presentation.
We'll be co-teaching.
There you go.
Okay, guys, 2 more quick things, and then we're going to wind it up. Our timing is perfect. I'm right on schedule. I like the way I'm able to do that. We're actually not going to get to a whole bunch of questions, but we do want to talk about, Michael,
Yes.
specifically for you, the 2021 legislative forecast. We introduced it a month ago when it was really in its infancy. It's had some maturing in a month, and there's some stuff we really are concerned about. So can you walk us through, number one, what's going on? Give us an update, and then, how can we help?
Okay. Yeah, I think that was well put. It is maturing. I mean, it's still, bills are still being submitted. I think bill drafting cutoff date may have recently just come and gone. But the reason I wanted to bring this subject back is because there is a greater push this year than there's been in years past on these rental bills. And there's both a long-term and a short-term lobby groups, if you will. And what I'm seeing now is the very real potential that there will be legislation that will be adopted that may, in an HOA setting, I'm speaking specifically now in an HOA setting, that may prohibit the associations from adopting long-term rental restrictions that would apply uniformly. And what I'm saying is, right now in the Condo Act, if you adopt a rental restriction, it only applies to any owner who votes in favor or an owner who takes title to the property after the effective date of the amendment. It's not that way in an HOA. You're free to adopt and it applies no matter what. But they're looking at adopting some language that would say if you're going to adopt a rental restriction, it would only apply to the owners who vote in favor or an owner who takes title after the fact. And when I say long-term, because they're talking about possibly carving out an exception for any lease less 6 months or less. And that's putting the short-term rental lobbyists against the long-term rental lobbyists, which last year killed the bill altogether, which I'm okay with. But that is going on in Tallahassee, and it's still, even though it's maturing, it's still infancy because session doesn't even start till March. But what I'm bringing this up now, I'm putting board members, your management team on notice of this possibility. And if as a community, as HOA community, you are considering wanting to limit rentals, I recommend you get with your council now, get some language drafted and get it out to the membership and have that approved prior to July 1st. Because if these amendments if this bill does get passed, it'll take effect July 1st. So it's something you have a little bit of a time, but it's something to start talking about and putting into consideration over the next few months. So that's really what I just want to bring to everybody's attention. There's some other craziness, but I'm not going to get into it right now.
Well, so you could prepare an amendment and you could e-vote to adopt it, which would be perfect.
I would think that too. Yep.
Good stuff. Okay. And Michael, your group does a good job. The lobby does a good job of reaching out to board members when you need us and to be vocal about, things that are not going in our favor. That's normal course for you. We can expect that in the next, 90 days, 120 days.
What you'll see is we do sometimes have call to action, and this comes through, as the chair of the legislative committee for CAI. These come from CAI. There'll be calls to action, and obviously they'll come to us as a member of CAI. And if you're a member of CAI, you'll get them. What I do though is then when I say I, KBR, we will email blast that to everyone, which includes you, Craig, and hopefully you guys will all share it with your own list of people who may not yet be on our list. And those calls to action encourage you to reach out directly to your local representatives, in your area, whatever part of the state you're in, senators and representatives, and let them know, yes, we favor this, or no, we don't. There'll be a form there. I encourage you to not just use the form. I encourage you to do it independently. And I even encourage you to pick up a phone and reach out to your local, because they want to hear from you. And the more they hear from us, either to support or oppose, the better we are going to be able to get something supported or opposed.
Opposed, yeah. Okay, good. Thank you, Michael. And we'll look for regular updates now through the session at this point in time, I guess.
Yeah.
Last one, guys, the division's stepped up some enforcement lately. Jeff, is there anything specific you think we should be looking at? Or
Yeah, I would like to think that the division is a friend to associations and not the enemy, because really they provide some great assistance. But it seems like they are focusing more on the assistance to the owners and punishing the associations who are trying diligently to comply. And if they make a misstep, you publish you do your financial reports. And let's say the audit, the company that's doing them is delayed. So now you're delayed in providing the notice to the members that it is available. And the member writes a letter to the division, you're going to get fined $3,000. That's just not right. I don't know what's happening in Tallahassee. I don't know what's happening at that level, but I really wish there would be a change of mindset. This notion that all the boards, the ombudsman's office was created because of, in my opinion, it's the myth of the condo commando. I'm not saying they don't exist. I'm saying that we represent over 1,400 associations and rarely run into it.
Right.
So I just wish it would be more, I wish they would take more of a helping hand.
Right.
They've really, they've taken on the role of penalizing. No more smack on the hand, don't do it again. They're penalizing. And I do believe they are focusing, Jeff, right on point. There's a very small percentage of very serious violations that they have decided to make statewide. And to that, I just want to add one thing, because about financials. Another course we're going to be having in January is on budget and reserves. And I encourage everyone to join that, because that is an area where we're seeing a very big increase from the financial investigators at the division, where if you're not addressing your financials correctly, in particular, if you're not addressing reserves, if you're not fully funding and you're doing less than fully funding or waiving, you need to make sure you're doing it right and documenting it right. Or they don't just say, you got to fix that. They say you have to fix it. And here's a 3,000. We're making the number 3,000 up. The number of dollar amount is in the thousands typically, though, because they base it on a dollar amount times a number of units, and it's just flat. And it could be very significant. So be on the lookout for that as well. We're going to try to get more education on that.
Good stuff. Well, guys, we've come to the end again. We always seem to run out of time. I want to do a couple things. One, for those of you who did chat in questions, there are a ton of questions on e-voting. Jeff's material and course will be out soon. My partner is doing his webinar on the 6th on specifically on e-voting. So all those questions will be answered at that time. I would say to you guys, I've been very appreciative of the guidance you've given our listeners and being able to do this with you for what seems like forever. But we look forward to continuing in the new year. This is our last one. So happy holidays to you and to our listeners.
Craig, you mean our last one for 2020?
2020, last one for 2020, exactly. So happy holidays to everybody. Cheers, and we'll see you in the new year. Take care.
Happy and a healthy new year to you, Craig, and everybody at Castle and all you listening. Stay well.
Thanks, guys.
Happy
Take care.
holidays. Happy New Year.
Better, Mike.